This Honorable Supreme Court of Tennessee is now in session.
Thank you, Mr. Hevner. Good afternoon, everyone. Welcome to the January 2022 Knoxville docket for our 1 o'clock case. We appreciate the attorneys appearing by Zoom. I know it's not the same as in person, and you've accommodated us with this, and we appreciate that. Welcome to those of you who are watching on live stream with our YouTube channel. In just a moment, Mr. Hevner is going to call the case for this afternoon. Each side has 30 minutes, so if appellant wishes to reserve rebuttal time, please let us know when you start your argument. Mr. Hevner, you may call the case.
Elijah Shaw et al. Versus Metropolitan Government of Nashville and Davidson County.
Good afternoon, Your Honor. Paul Avalar on behalf of plaintiffs, appellants, homeowners, Liz Shaw and Pat Rayner. I've attempted to reserve 5 minutes for rebuttal. When this court granted review, it did so as to both issues presented, both mootness and the merits, and I will address each in turn. First, this case is not moot because Metro cannot meet its burden to show mootness under Norma Faye Piles. That requires a permanent policy change that solves plaintiff's injury that is not likely to be abandoned, and Metro can't meet any of those requirements here. At best, what we have is a voluntary, temporary, ambiguous change with further Metro equivocation about the state of homeowners' rights. And homeowners' injuries haven't been remedied because, unlike the privileged home-based businesses, which continue to be allowed 12 clients daily, homeowners only get 6 now, and only until January, where that number likely drops to 0. So we continue to be discriminated against as complained in our complaint, and we continue to have the uncertainty going forward of whether we will be allowed to have any clients or not. Under Norma Faye Piles, that means that Metro cannot meet its burden here.
This is Justice Bivens. You're stating that it would likely resort back to 0, and I realize it looks like Metro had been silent on that for a good while. But has Metro not now said that once the new provision expires, that there will be no restrictions in the code unless specific action is taken by the council?
Not quite, Your Honor. Metro's taken a variety of positions over time, and in its merits brief to this court, it said that all of Section 250D will come out of its code at sunset. But what's left uncertain is whether or not that means that homeowners, home-based businesses will be legal without limitation as to clients, or whether they will be totally illegal. That's still unclear. And so, in fact, homeowners may be worse off in January even than they are now. That's the reason that that uncertainty is the reason why the burden is put on the party claiming mootness. Mootness can't be done by ambiguous or half-hearted steps. It has to be clearly abandoned, and this is not.
Mr. Avalar, go ahead, Chief Justice.
This is Justice Page. Don't governmental entities have a good faith presumption in circumstances like this? And one thing that struck me when I was reviewing is the Metro prevailed at the trial court level and then repealed the prior ordinance and enacted the new one during the appeal after they had won in Chancery Court.
Your Honor, we don't view this case as being about good faith at all, because the ordinance on its face is not permanent. It is temporary. And the ordinance on its face continues to discriminate against the homeowners. And so regardless of any statements that Metro makes about its future intentions, and here it has made several over time, those statements can't overcome the plain language of the temporary ordinance.
Mr. Avalar, let me probe a little bit about the nuances of what will happen if the sunset provision kicks in. Does the sunset provision apply to the repeal of the client prohibition, or does it apply to the affirmative designation of 6 clients or less?
Your Honor, it's not clear, and Metro has said multiple things. Metro's latest statement is that The sunset provision means that all of subsection 250D will come out of its code, which means that home occupations as an accessory use with special restrictions will come out of the code. Now, it's not clear if that means that then home occupations will be essentially unregulated, or if that means that home occupations will no longer be an accessory use.
Well, Metro will be able to clarify if my understanding is incorrect, but my understanding of their position now is that the sunset provision does not apply to the repeal of the client prohibition. So that would leave the repeal in place, and I guess there would be no prohibition on clients at all. Is how I take it. I'm sure Metro will be able to clarify it if I'm wrong. If that is correct, where does that leave us?
Your Honor, we still have a live injury because Metro's code today continues to treat the homeowners differently in a discriminatory way than the privileged home-based businesses.
Does your complaint speak to the revised provision? If you say the new provision discriminates against your client, is that what your complaint is aimed at?
No, Your Honor, the complaint is aimed at the discrimination generally. And so when a revised ordinance or statute.
No, my question was, is your complaint aimed at the new revised provision? Not whether you allege discrimination generally, but has your complaint been amended?
No, Your Honor, it is not, because the amendment happened after the record was closed and we were already up on appeal. We'd already filed our opening brief.
Where does that leave us?
Your Honor, that means that we still have a live case. The case that I would direct Your Honors to is not just Adirond, but also from the U.S. Supreme Court, a case called Northeastern Florida Chapter of Associated General Contractors of America versus City of Jacksonville. My apologies, it doesn't exactly roll off the tongue. But that's a case in which an ordinance from the City of Jacksonville was challenged. And on appeal, the ordinance was tweaked slightly so that the exact provisions were not the same, but the same general gravamen of the problem was there, continued discrimination. And in that case, the U.S. Supreme Court said, this case is not moot. The essential gravamen of the complaint of the discriminatory treatment continues, and therefore we can decide this case. More recently,
I mean, isn't this case different? Here, the provision that your complaint is aimed at has been repealed altogether. It's not that it was amended or revised, it's been repealed, and another provision has been enacted that is not mentioned in your complaint. I mean, what do we have?
The restriction on clients has not been repealed, it's been amended. That restriction, my clients continue to be restricted as to clients at their home-based businesses and continue to be restricted in a discriminatory way. That 6 versus 12 problem continues to exist. And the record that we have here already speaks to whether or not my clients are similarly situated with the privileged home-based businesses, the harms, the germane requirement, all the rest of those things. And so the injury continues, and this case is not moot.
Mr. Avalar, this is Justice Bivens again. I understand your point about the record being closed essentially, but before the statute was amended, and it does put us in a peculiar procedural posture. But in fact, wouldn't it be necessary to better develop a factual record with regard to the amended ordinance than what we have before us here now?
So a couple of points, Your Honor. First of all, the revised ordinance goes from 0 to 6 versus 12. So 0 versus 12, 6 versus 12. That matters only if facts matter in this litigation. And of course, Metro's position is that facts don't matter. And the Chancery Court's decision is essentially that facts didn't matter. And so if this court is thinking that it needs to remand for further factual development, it needs to make clear upon remand that the facts matter. in this litigation. Beyond that, Your Honor, I think the uncontested record already speaks to the essential elements of at least the equal privileges claim that would continue. That is, the homeowners continue to be similarly situated to the privileged home-based businesses because they're doing exactly the same thing. And the record continues to reflect that they have no effect on their neighborhoods when they operate, as opposed to the privileged home-based businesses, which have greater effect and nevertheless are privileged to have clients. And so those elements continue, those elements are established, and there's not really anything on remand that will change about those things. But again, if 0 versus 6 versus 12 is an issue, it's only because facts matter, and that much at least has to be made clear on remand.
Mr. Avalar, this is Justice Lee. I'm sorry, go ahead, Justice Lee.
Mr. Avalar, this case presents this court with a good opportunity to clarify this standard regarding mootness when it involves the government cessation of activity or conduct. What do you say that standard should be, and how should it be applied?
Your Honor, that standard should be what Norma Faye Piles said it was, as this court, I think, recognized in Hooker v. Haslam. That is, there has to be a permanent policy change.
But that's not what Norma Faye Piles Lynch family purpose case says, is it? Can you state what you think it says? Because as I read it, it says, if the court may, if justified by the circumstances, require the opposing party to show why the proceedings should be dismissed for mootness. So what do you think justified by the circumstances means? And did Norma Faye say you had to show it was a permanent change?
Your Honor, so Norma Faye Piles says that the burden is on the party claiming mootness, and we think that is correct. It says we're loath to treat the government differently, better than other litigants. We believe that is correct. As to the good faith element, we think that goes to the likelihood or not of the government potentially abandoning its change in the future. The permanent change language is a direct quote from Norma Faye Piles. I don't have the site at hand, but it says a permanent policy change not likely to be abandoned. And so let's look at that in light of Hooker v. Haslam, in which case there was a challenge to part of the judicial nominating and retention provisions. And the commission part of that challenge, that law sunset. So it went away forever without further government action. And in fact, the legislature then took affirmative steps showing that that would not come back by proposing a constitutional amendment that abandoned entirely that provision. I think that's really what the standard is here. If Metro had passed a non-sunsetting provision that treated the homeowners here exactly the same as the privileged home-based businesses, and again, it did not sunset, I could agree that we were moot. But under these circumstances where it's the alleged fix sunsets, goes away, what's left after that is uncertain. And we have 18 months of various statements from Metro, including conflicting statements made to this court. In those circumstances, whatever presumptions maybe could be made in the government's favor, just can't under these particular facts and circumstances.
Well, how does Mr. Avalar, I'm sorry, go ahead, Jim.
No. Well, how does that standard differ from speech first? Because speech first refers to showing a clear indication that the change is not genuine. Or are those essentially the same standards?
I don't think so, Your Honor, because speech first talks about this special solicitude. And as applied by the lower court, what that essentially means is an immediate shift in the burden to the party not claiming mootness when the party claiming mootness is the government. Tennessee's standard, to the extent it allows that shift to happen at all, is more, as the court said in Norma Faye Piles, jaundiced. It's going to require more from the government. There has to be an indication like this is a real and permanent change. And here, again, this isn't even about whether Metro had good faith or not in changing the statute. The important elements here are it continues to discriminate against the plaintiffs in a way that is raised by their complaint, and 2, it sunsets. and we don't know what's going to happen next, that uncertainty weighs against the government when it comes to mootness, even if it wouldn't weigh against the government when it comes to ripeness. And as the Lujan court recognized, there's a big difference between the two when you're talking about presumptions.
But Mr. Avalar, doesn't the speech first standard just recognize the obvious difference between a private actor and a governmental actor? With a private actor, you're not going to have legislation. They don't control legislation. It's just either them ceasing the conduct or not ceasing the conduct, and then you can look at their words associated with it. In a governmental situation, here you have the governmental body involved repealed the provision that your complaint attacks. There's no sunset provision to that repeal. I mean, if you were going to apply Hooker versus Haslam, does Metro have to propose a constitutional amendment? I mean, I really don't know what you do beyond repealing the provision that your complaint.
Your Honor, you repeal it without a sunset provision. That's the answer.
What if the sunset provision does not apply to the repeal? If my understanding is correct, and the sunset provision does not apply to that.
If the sunset provision means that all of 250D comes out of the Metro Code, and that further means that come January, my clients' home-based businesses will still be allowed to operate and on the same terms as the privileged home-based businesses, then that part of the case that claim would be moot. But again, that doesn't change the fact that as of today, right now, Metro continues to treat my clients worse with regard to clients than the privileged home-based businesses. And for that reason, at least our equal privileges claim is not moot.
Mr. Avalar, this is Justice Page. As Justice Kirby's pointed out, I mean, your challenge was to the previous provision that says no clients or patrons could be coming on the subject property. That's been repealed. You've won that. And now they can have up to 6 people a day. This is an as-applied challenge. Is there anything in the record here showing that your clients are not enjoying 6 clients a day and that's all they need to operate their business?
Your Honor, after the ordinance was adopted and Metro moved to essentially expand the record on appeal under Rule 14, we also submitted declarations from our clients. And the declaration of Mr. Shaw at least said 6 is not enough, 12 is what I need, and therefore I am still injured. And so again, we have that is in the proceedings below, we have that. And so that injury has continued. And on the face of the statute, they continue to be injured by that.
Is there any declaration in the record from Ms. Rayner?
Ms. Rayner's position is slightly different than Mr. Shaw's because Ms. Rayner is older and is essentially winding down her working career. Over time, she has fewer and fewer clients. I'm not sure what that number is today, but I confess, Your Honor, I can't remember exactly what she said with regard to whether 6 was enough for her right now. But at a minimum, Mr. Shaw did say 6 was not enough, and so that injury does continue to this day.
Let me ask you this, Mr. Avalar. If we were to adopt the standard as reflected in Speech First and remand it to the trial court to apply that standard, would that serve your purpose?
Your Honor, it would mean that the lower court, that the Court of Appeals had erred in simply declaring this case moot. A remand would allow us to
remand it to the Court of Appeals to apply this. I don't know.
Your Honor, we believe that any remand has to be accompanied by a further direction saying that facts matter. Because again, if facts don't matter, 6 versus 12 versus 0 doesn't matter, and that's what the Chancery Court said. Again, that this change may have been material reflects, I think, this court's recognition that in this case, facts do matter. And based on the uncontested record that we have here, we still believe that this case can be decided by this court on the merits under its de novo review, because the record continues to reflect that our clients do not harm their neighbors, that all of Metro's purported justifications for the client prohibition don't apply as, given the particular facts of the homeowner situation here, and that the justifications that that Metro claims justify its restrictions on clients apply even more heavily on the privileged home-based businesses who are nevertheless allowed to have more clients than my clients still today, at the beginning of this case, and likely in January once all of this comes crashing down. So,
Avalar, this is Justice Bibbins again. Isn't the fact that there's a declaration from Mr. Shaw saying 6 is not enough, and based on what you're saying, Ms. Rayner may well be okay with 6, doesn't that point out a factual issue that hasn't been resolved by the trial court?
Your Honor, there's again, because mootness came up on appeal, of course, the Chancery Court had no opportunity to do this.
Understand. I guess that's my point. That's not in the record through no fault of yours, but the fact of the matter is it's not, because this happened after the decision.
That is correct, Your Honor. But again, if that's the direction that this court wants to go on remand, again, Your Honors, we would strongly urge that the remand be with instructions, because if 6 versus 12 versus 0 matters, again, it is only because facts matter. If you remand to the Chancery Court's position on this was that facts don't matter. And so something from this court has to change that standard, or instruct the Chancery Court that that's not the wrong standard, and that the Chancery Court is to consider the uncontested, but the 50-some pages of uncontested material facts that we put in the record about the particulars of our client's circumstances, and how those simply don't match up with these general hypothetical theories.
But why would we even, I want you to explain why we would even remand in this case. Your complaint attacks a provision that's been repealed. The trial court finding doesn't address the provision that is in force now. I don't understand what there is to remand at this point. The trial court ruling that you appealed, it doesn't mean anything anymore, because it is as to a provision that doesn't exist and is not subject to the sunset provision.
Your Honor, again, I would point you to the Northeastern Florida chapter of Associated General Contractors, which is essentially the same sort of circumstances that we have here, where on appeal, the provisions are changed, but as the Supreme Court recognized, the essential gravamen of the complaint remains: unequal treatment. It doesn't matter if the code has been tweaked, so long as that core remains, so long as there is anything for the courts to remedy, the case isn't moot. Adirondack Construction says the same thing, where that potential injury continues to hang out there. The case isn't moot. And so this case can't be dismissed as the Court of Appeals did. At best, it can be remanded for further factual development on this 0 versus 6 versus 12 issue. But again, Your Honor, we believe that the record is clear that the 0 versus 6 versus 12, that is already taken care of under equal privileges, given the record we already have. Because again, the record is uncontested. There's no evidence our clients caused any harm. All of Metro's purported claims about why they restrict clients, our clients don't implicate those concerns. That's the Schatz case. Moreover, Your Honors, the record also reflects that the privileged home-based businesses who continue to be privileged above and beyond what the homeowners here actually cause more harm that Metro says justifies the restrictions on clients. And so all of that's already in the record. And so for those reasons, we don't think that a remand on those issues needs to be done. But again, if the 0 versus 6 versus 12 issue prevents this court from deciding the merits, it's only because the facts matter and the facts may have changed. Again, that's not the standard that the Chancery Court applied. And so if we're remanded, we would ask for instructions that those facts, of course, do matter. Your Honors, I want to make clear here that Metro's position isn't that the facts of this case are contested. The record at 2257 reflects Metro's position that the facts of this case are uncontested, but that they are not material. That is, they're not relevant to the inquiry under the Tennessee Constitution. Based on all the numerous sites and arguments in our briefs, we believe that's wrong as a matter of Tennessee constitutional law. It's even wrong as a matter of the federal constitutional law that Metro relies on. And so again, at a minimum, the remand has to be that facts matter. You must consider the facts. And with that, Your Honor, I can see at about my 5 minutes. I'd like to reserve the balance for rebuttal. Thank you.
Thank you, Mr. Avalar. Ms. Fox?
Yes, Your Honor. Laura Fox, representing the Metropolitan government in this case. Your Honors, this lawsuit was brought to challenge one sentence out of one ordinance in the whole Metro Code. That one sentence has been repealed, and there's no provision for it to come back at this time. What we have instead was a replacement provision that lets the plaintiffs do what they wanted to do. Now, maybe not quite to the extent that they want to do, but they haven't challenged that new law. And so it's Metro's position that this case became moot once the one provision was repealed, and certainly when the plaintiffs were allowed to do what they want to do.
Ms. Fox, this is Justice Bivens. So what is the definitive position of Metro with regard to if this most recent amendment sunsets as of January 2023? What happens at that point? Are there restrictions or are there no restrictions on these particular plaintiffs?
There would be no restrictions at that point because there would be no prohibition on having clients come to your home. I think that it took me a little while to get to that level of certainty, honestly, to try, because I don't know if that's what counsel intended when they did that. But I've studied it again and again, and I think that is the answer. There are no restrictions at that point. I'm sorry if the plaintiffs have been frustrated by the Department of Law's unwillingness to take that certain a position, but they were also asking questions like, they wanted us to promise that the sunset would not be extended and things like that, that certainly we can't bind the council on that provision.
Well, it would be easy to answer that in two separate questions, couldn't it? And answer the first question and say what happens if they don't, and tell them that you can't guarantee that Metro's not going to pass anything.
I think that at this point, what we know is that the client prohibition has been repealed. We know that it's replaced with something that lets them do what they want to do, and that if it's gone, there is no provision in the Metro Code that restricts clients from coming to your business.
Ms. Fox, this is Justice Page.
Yes.
What about the argument that Mr. Avalar's clients being treated disparately? We know there's a lot about the temporary rentals and things like that in Nashville where people use their homes to make money. There's several other examples, and he's saying his clients are being treated unequally. How do you respond to that?
Yes, the trial court gave a very thorough analysis of the rational basis behind all the entities that the plaintiffs felt were being treated more favorably, and why they thought that why there was a rational basis for all those entities being treated differently. And when there is a rational basis that supports a use, the judiciary does not become a super judiciary and say that is wrong as a policy decision. There is a rational basis review, and if there is any reason that supports the the rational basis, then that's good enough. And that's been the law under McAllen, under Fallon, under small schools. The plaintiffs have strung together some cases that talk a bit about fundamental rights in a vacuum, but they've never presented any cases that would overturn those land use cases or cases that study due process or equal protection. And those cases clearly say that the standard is rational basis.
So do we now analyze that issue under the revised ordinance? Is that?
I don't think so.
If so, it's not moot.
I don't think that it would be appropriate for this court to analyze that, because I consider it to be a very significant difference to be able to have no clients come to your house versus to be able to have 6. I think that I think there would have to be evidence about how has that affected the plaintiffs, and I think that Metro would have to have a chance to respond with evidence about how the new policy is going. So just because,
Ms. Fox, if you're taking that position, but is Mr. Avalar correct? In the trial court, Metro took the position that facts don't matter, that it's a straightforward matter, and that's in essence what the chancellor held?
Well, absolutely, we never have taken the position that facts don't matter. I think what he is referring to is the fact that we did move for a motion to dismiss, and we talked about the rational basis for this ordinance at that time. And there are many cases where a rational basis has been met on the motion to dismiss standard. The chancellor in this case decided to go ahead and have depositions taken and have discovery taken. And so this case has more facts than any other rational basis case that perhaps I can think of right now, because we had a 30.026 witness for the Metropolitan government who spent 3 hours articulating the rational basis for all these distinctions and things like that. If you look at the trial court's opinion, it's very detailed. It goes over all the facts for both the plaintiffs and for the Metropolitan government. And I think what plaintiffs are frustrated is that they wanted to be able to negate every single rational basis, and they've not been able to do so.
Ms. Fox, this is Justice Lee. What standard should we apply in determining whether a case is moot, and who has the burden of proof under that standard?
Well, if there was any case that where it made sense for the burden of proof to shift from the government to the other to the plaintiffs, I think it would be this case. And I say that because Metro didn't have to adopt this new ordinance, in the sense that, there was no judicial pressure to do so. The trial court said it was constitutional to still have a client prohibition. But honestly, the plaintiffs have won in the court of public opinion. They've convinced they or other folks who want to run businesses out of their home have convinced the 40-member Metro Council that this is a valuable thing to allow people to do in their homes. And so I guess sua sponte, you could say, the Metro Council changed its policy and decided that this was something that Metro wanted to allow folks to do. And so there's no artificial pressure that caused this change.
So if we apply the Norma Faye Powell standard, then you would say that the court would be justified by the circumstances being Metro's voluntary change in conduct or repeal of that ordinance. And then the burden would shift to the opposing party to show why these proceedings, to show why this change was not permanent. Would that be a fair statement?
I think that's a fair statement.
And how would they show it's not permanent? How would they do that in a similar case or in this case?
Well, I think it'd be pretty tough in this situation because we have a policy that the council appears to be now thinking that it's okay to have people have clients come to the business. So I think it's difficult to say that's not a permanent change. And I think we can, honestly, I guess
It's not easy. It's not difficult to say it's not a permanent change when it's out there and there's a sunset provision, is it?
Yeah, that's what bothers me. I mean, the sunset provision really throws sort of a cog into this, doesn't it? I mean, it makes you wonder, like, why are you sunsetting it if it's such a great idea? And then what's going to happen then? And you don't, once this party, garners the resources to bring this action, and then the government changes courses basically midstream, just don't know how fair it is to the other party to just switch directions like this.
I agree that the sunset provision throws a cog in the wheel, but I think that if we look at the repeal of the client prohibition, and that part is not sunset, and then we look at the new provision, which says you can have up to 6 folks, clients come to your house every day, then I think we're in a situation where we can say that the current policy is that we are going to allow clients to come. And I think that, the Metro Council ordinarily, when there's a sunset, I think it's because you want to see how it's going. And so I would guess that they would check in on that and decide if it's going well, and maybe they want to change it to 8 people a day or something like that. I find it hard to believe.
Or change it the other way and say, oh, that didn't work out. No clients, or 1 per day. So, I mean,
if we rule this as moot, then the plaintiffs have to go back to court and start all over again.
Well, I think that, first of all, if they have to start all over again, you can introduce depositions and discovery from a previous case, so they're not starting from scratch. But I think that it doesn't make sense to me that a court would keep a case open indefinitely. What if the sunset was 5 years off? I think that would be, it doesn't make sense to me that I agree that the sunset adds a kink into it, but it doesn't make sense to me that it continues to be a live case during all that time. I think that if you, let me just talk for a second about the totality of the circumstances analysis, which was the Sixth Circuit's, I believe, speech first, and what the Court of Appeals talked about. If you look at the totality of the circumstances and what is reasonably likely to happen, I think it's most likely that they will continue to have an ability to have clients at their home, because that's the current policy. It took decades to overcome the client prohibition, and that's been overcome. And so I think that if you look at that whole totality of the circumstances test, it seems likely that we're going to continue on the current course that we are now.
Ms. Fox, this is Justice Bibbs. Are there other cities within or cities within Tennessee or other large cities across the country that have a policy similar to or an ordinance similar to this, either the initial one or the amended?
I don't know the answer to that. The plaintiffs have indicated that Nashville's policy is unusual. I had seen some at the beginning of this case, but I don't have those ordinances in front of me today. But I do think that the suggestion that the plaintiffs have made that this is a constitutional issue, that this implicates a right to work, I think that absolutely is mistaken. And I say that because the cases they rely on, such as the watchmaker case, who was required to be licensed in order to, not make watches, I think, but it was to repair watch. He couldn't practice his profession anywhere. But that's not the same as what we have here. Here we have folks who have skills and they can do those skills outside the home, but they are asking to do it in a residentially zoned property. And so I don't think we had the same heightened standard that we would for someone who's not able to perform their job function anyway. And I think that it's a reasonable restriction at sort of in the residential limitation, just as if you were to say I have a fundamental right to vote, well, I don't get to vote in the district next to me. I mean, there are restrictions on where I can do things. And so this is just a restriction on where they can cut hair or where they can record music. I think as far as the mootness, I think it's really as powerful that the council had no court pressure to change what it was doing. The Metro government had won in this case, and the council did this voluntarily. And there is no evidence that this is a temporary evasion to try to, avoid judicial review. This is something that the council undertook without asking me, without asking the situation of the court. It's just a public pressure situation where there is a public pressure to be able to have clients come to your house. And I do think that, again, this is a legislative issue. It's a legislative question that's been going back decades, and we presented to the court the Howe case from 1940 that talked about restrictions on commercial uses, and the Davidson County versus Hoover case from the Tennessee Supreme Court in 1963 that said you can't have beauty shops. And the courts in both those cases, the Supreme Court said these are legislative decisions. And I think that's what we have here, honestly. If it was to be remanded, whether you have 6 clients come a day or 8 clients a day, I don't think the courts ordinarily get into that level of detail on a city ordinance because we have the separation of powers. And those are legislative decisions about how many clients are going to be sufficient to allow people to work from home and how many are going to overwhelm the neighborhood with their traffic. And those are really legislative lines that are drawn and not judicial lines. This is a case where we had discovery, as I said, we had summary judgment. The court considered all of the many reasons that the plaintiffs had for why they thought that they were not being treated fairly, and found that there were rational reasons for all the differences that had been pointed out. And so for all those reasons, we believe that the prohibition on the client visitation is gone from the Metro Code. It doesn't make sense to leave the case open indefinitely. It doesn't make sense to remand it for an analysis of 6 versus 4 versus 12, where the plaintiffs have never challenged the new ordinance. And so this is not some attempt to temporarily evade judicial review. This is as permanent as an ordinance can be, I would say.
Other than filing a separate lawsuit, how would they have challenged the new statute, the new ordinance?
Well, you could file a motion to remand at the Court of Appeals, I suppose. And I mean, if we go back to the trial court, I think there would have to be some additional discovery at that point. And the timeline that we're in is a difficult one, where the sunset takes place in January of next year. So I just don't think it's a situation where there is an active law that is affecting them at this time. I really think this is like the City of Memphis versus Trey Hargett, where the Tennessee Voter Identification Act changed and the requirements changed, and the court said our interpretation would not be meaningful because the law has changed. So this court's interpretation of the client prohibition, the total ban, would not be meaningful. And if we remand it, I'm afraid that we'll be back in a situation where we have 6 client allowed now, and then, well, it's their burden to challenge the new lawsuit, I think is the best way for me to say it, I believe. And so for all those reasons, Your Honor, we ask that this case be dismissed as, continue to be dismissed as moot, that the Court of Appeals decision be upheld, and that this case be dismissed on that ground.
Thank you, Ms. Fox. Mr. Avalar, your rebuttal.
Thank you, Your Honor. Just a couple of points. First of all, Metro's counsel just conceded that homeowners still cannot do what they want. That means the injury is ongoing. She also said that her position on no restrictions on clients come January is not, she doesn't know if that's what Metro Counsel meant, and she can't bind Metro Counsel in any event, and also reference the decades of unequal prohibition on clients that the Metro Counsel has had in place. And so for all of those reasons, the most realistic set of circumstances here is that the homeowners are still injured, and that this case, and that the client prohibition, certainly the unequal client prohibition, has not been completely and permanently abandoned. And for that reason, under Norma Faye Piles, this case cannot be moot. Secondly, Metro's position on the 0 versus 6 versus 12 is that it doesn't matter. As to the question, did Metro take the position that facts didn't matter? The record at 2257, quote, "The particular facts of this case are largely irrelevant," unquote. And they repeated that argument in the Court of Appeals, that they were completely irrelevant. And here in this court on the merits, what Metro has said is that the rational basis standard that it thinks applies is a question of law, not of fact, and that rational speculation is enough to carry the day. But what the cases say, Your Honors, is that if that speculation is overcome by a factual record, then the plaintiffs can win under one of these cases. In the federal courts, you've got cases like Craig Miles, and in this court, you have a case like Schatz. I mean, Schatz is an...
I'm sorry, this is Justice Kirby, Mr. Avalar. I want to follow up on the question that Justice Lee has posed repeatedly on the standard that we should employ on mootness. Ordinarily, if the provision being applied to a plaintiff, such as yours in this case, is repealed, game over. It is moot. And as Justice Lee mentioned, the burden then falls to the plaintiff to show the evil in voluntary cessation is a defendant gaming the system, temporarily stopping the misconduct in order to escape the effects of the litigation. If the burden falls on you to show that's what Metro is doing in this case, I mean, what do you have? They didn't lose at the trial court level, and they've repealed the provision.
Your Honor, first of all, they haven't repealed the provision. They have temporarily amended it. It remains the case that our clients are restricted as to the number of clients they can have at their home-based businesses, and restricted more so than the privileged home-based businesses. That's not a repeal of the restrictions we're challenging. It's an amendment to those restrictions.
Is there any indication that the evil of voluntary cessation, a defendant gaming the system to try to escape the effects of the litigation, do you have anything that shows that that is the case here?
Your Honor, Metro's Rule 14 petition in the Court of Appeals at page 1 said, now that we've temporarily repealed it, our position is we've wiped out all the facts of the record, and so this case can go away. We have built over the course of years an extensive, uncontested factual record, a record that Metro said it didn't contest, it just said that they were irrelevant. And then its temporary amendment of the challenge provision, they claimed wiped out all of those facts. Your Honor, that's not the case. And again, the Northwestern Florida contractors case demonstrates that in these circumstances, the case isn't moot, and the court should continue to hear the case because the plaintiffs are injured in the same way. The gravamen of their complaint continues. They are restricted, even though, as in Schatz, there was no public health, safety, general welfare, morals reason for doing so. And they are restricted unevenly, even though the privileged home-based businesses under Metro's own justification for the restriction are in fact the bigger problem. What the homeowners here do is no different than what Metro allows thousands of other people to do. And for that reason, the equal privileges provision of Tennessee's Constitution has been amended or has been violated. You know, Ron, for all those reasons, we think that this case is not moot and that we are entitled to a judgment on the merits, but at a minimum, this court should remand with instructions to consider the facts under Tennessee's Constitution. Thank you, Your Honors.
Thank you, counsel, for those fine arguments. We appreciate that very much. We will be in recess now until 2:30 Eastern Time for the remaining case on the docket. Thank you all.
This honorable court is now in recess until 2:30 p.m.